Hi, very good morning. Another interesting judgment under the Arbitration and Conciliation Act. Delhi High Court citation is Airports Authority of India versus TDI International. Question was there are four questions. One is AAI. I am not giving the full facts. I am going to give only the law portion of it. A, that is Airports Authority of India, we will call it as AAI. AAI unilaterally appointed an arbitrator. Award was given. Then AAI itself challenged that award, saying that the unilateral appointment of the arbitrator is void ab initio. So the award is also void ab initio. This is the contention of AAI under Section 34 petition before the High Court. The submission was that the award made by such an arbitrator who was unilaterally appointed has no legal effect. AAI argued this. The opposite party, TDI, they submitted this principle is not applicable in this case because you yourself appointed the arbitrator and now you are yourself challenging the award. So they said this is not applicable. The principle that unilateral appointment of arbitrator is void ab initio is not applicable in this case. That is what the argument of TDI. Delhi High Court noted the principles laid down by Supreme Court in this connection. The Supreme Court held that appointment of arbitrators by persons who are themselves ineligible to act cannot be permitted. Such an appointment would be de jure ineligible to act as arbitrator. The waiver under Section 12(5), that is 2015, they brought under an amendment. I will tell you what is the amendment. I will touch upon it. Just understand this. The waiver under Section 12(5) requires an express agreement in writing to that effect. And the conduct of the parties, this is very important, including participation in the arbitral proceedings, would be insufficient to infer such waiver. Hence, the award made by the unilateral appointed arbitrator is itself a nullity and void ab initio. It cannot be considered as an arbitral award under the ANC Act. So, what the Supreme Court said was that merely because you participate in the arbitration proceedings, that cannot be said to be a consent. Unless it is given in writing. That is what the Supreme Court said. A division bench of Delhi High Court also held that proceedings for execution, this is very important again. Proceedings for execution of an award made by a unilaterally appointed arbitrator are not maintainable. So, based on this Supreme Court judgment and the division bench judgment of the Delhi High Court, in this case, the Delhi High Court held that even though arbitrator was appointed by AAI, the award can be challenged by the AAI. Person who appointed the arbitrator, he himself challenges the award as void ab initio. Then the question was applicability of Section 12(5). As I said, I am not going to give in detail. Section 12(5) was introduced in 2015. The section merely says any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as arbitrator. This is brought into force 12(5). Earlier, the people were appointing anybody who even had relationship with them, their employees, their directors, or whoever it is. Now, schedule says whoever is having a relationship with that person, because the arbitrator has to be not biased in his approach. So that is why they brought a schedule. Whatever is the relationship, they have specified in that schedule and said they are not eligible. But this was brought in 2015. So the challenge was, they said, the TDI said, which is the opposite party, they said the proceedings commenced even before the Section 12(5) came into force, and hence this section is not applicable. Delhi High Court said no. Even if proceedings commenced prior to Section 12(5), it would govern an appointment made thereafter. So it does not matter whether the proceedings commenced before the introduction of section 12.5. If on the appointed date, if the section was there, then it will govern. That is what Delhi High Court said. Then the another interesting argument was AAI has waived its right. That was the contention by TDI. The contention was they made two contentions. One, by participating in the proceeding and the party's consent was recorded in the order award itself. That is point number one. So they have given consent. They have waived the section 12.5. Then second is the objection. This objection, that unilateral appointment of arbitrator, this objection is raised for the first time in the course of arguments before the High Court. So you cannot, first time you cannot raise it by way of an submission before the High Court. Either it should have been in the pleaded. First, it should be raised before the arbitrator itself. Second, it should have been in the pleadings. It is not there. You are just orally raising this objection. This was the contention. Delhi High Court held that the requirement of law is an express agreement in writing. That is what we sought. Notwithstanding anything, any prior agreement to the contrary, etc. Then the proviso says, provided that parties may, subsequent to disputes having arisen between them, waive the applicability of this subsection by an express agreement in writing. That is what the proviso said, section 12.5 proviso. So Delhi High Court says that there should be an express agreement in writing. Merely participating in arbitration proceedings, even filing of claims or counterclaims, or even recording of consent in the order of arbitrator without objection or demur is insufficient for the purpose of section 12. Where is the express agreement in writing? You show it to me. If it is not there, just because they participate in the arbitration proceedings, or even if they give their consent orally to the arbitrator, that is not enough as per the law. That is what the Delhi High Court said. Delhi High Court relied on a judgment of its coordinate bench, which held the question was one of jurisdiction. This is important. The coordinate bench of Delhi High Court said it is one of jurisdiction. This can be raised by way of an amendment, and even without the same, even without an amendment, the question of jurisdiction can be raised. That is what the Delhi High Court says. Now, in the course of the arguments, the opposite side, the TDI, brought one judgment, which is against the view taken, which was taken by the High Court, the coordinate bench. So, which judgment will prevail? Because there are two contrary judgments. One is in favor and one is against. So, the attention of the Delhi High Court was brought to the notice. In a later judgment, the division bench of Delhi High Court held that the ground cannot be raised for the first time in a petition under section 34 of the Act. Because in that case, the court said, you should have said this before the arbitrator himself, the question of jurisdiction. You did not raise this plea before the arbitrator. Now, for the first time, you cannot come and raise it before me. That is the later judgment of the Delhi High Court. Then the court says, so court noted both the contrary judgments, and now it's in a question of fix which judgment to be followed, because there are two judgments. One says unless you raise it in the lower forum, that is before the arbitrator, you cannot raise the question of jurisdiction before the High Court. Another one says no, it is not necessary. Even if it is you have not raised it before the arbitrator, even if it is not there in the petition, you can even raise it orally also. That is another judgment. Which one to follow? When there are two contrary judgments, which judgment should be followed by the court? That was the question before the court. Then the court, Delhi High Court, relies on a Supreme Court judgment, which held that in the event of mutually irreconcilable decisions of the Supreme Court being cited before the High Court, the inviolable recourse is to apply the earliest view. If there are two contrary judgments which are produced before the court, then which judgment to follow? Supreme Court says, what is the earliest view? that must be taken and followed. That is the judgment of the Supreme Court. THC, following the judgment, the earliest view was you can raise it at any time, even if it is not raised before the arbitrator, or even if it is not taken in the petition. But orally also you can raise the question of jurisdiction. Hence, Delhi High Court said, I am following the earlier view as per the principles laid down by the Supreme Court. Delhi High Court set aside the arbitral award and asked the parties to agitate their claims afresh before the another arbitrator. That is what this judgment is. Very interesting judgment. Hence, I thought I will share with you. Have a great day. Bye. Thanks.